benefit. And so you as the employer would be collecting the information and evaluating it and determining whether or not the employee has a quote unquote serious health condition and whether they meet that definition. And then of course you'll be looking to see if they meet the other criteria for actually taking leave. And then as I discussed, the family member is a defined term. So under the federal law, we're talking about a spouse as defined where that person lives. A child or a parent, which also includes biological, adoptive, stepchild, or foster children. So that's the definition under FMLA. The definition under Washington law is going to be much broader, and we'll talk about that in a minute. Yeah.
Does that mean the line where it says employer makes the determination whether the employee meets the required standard? Does that mean we have the right to say, oh, what's your condition?
Well, I'll get in. Let me talk about the next one. So there's notice requirements. So when you become aware of the fact that an employee either has been missing work, or maybe they have a spouse who has cancer, or a spouse that's having some kind of issue, you as the employer have the right to either evaluate based on the information that you have. Maybe the employee has come to you and said, my spouse has cancer, I'm going to need some time off to take care of him or her, and I'm probably going to need to be out of the workplace for 6 weeks while they undergo treatment. You can make an evaluation based on that, or you can ask the employee to take a document to their healthcare provider or their spouse's healthcare provider, depending on the circumstances, and have that healthcare provider provide information about the need to be out of the workplace.
But what if it's so vague that you just have to get the doctor's? Because I received a doctor's notice saying that she's taking time off. Mm-hmm. Didn't tell me why.
Did you use the FMLA paperwork?
No, she's doing through PFML.
Okay. So under paid family and medical leave, you don't have the right to collect any medical information, which is hard for the employer. But under FMLA, you do have the right to collect the information from the healthcare provider. And so they would give you more information about what is the condition and why does this person need to be out of the workplace. So once you have some indication that this person needs to be out of the workplace, whether it's for their own serious health condition or a family member's, go ahead.
Kind of to what she was saying, there's an approval that comes from PFMLA. Can you request that as an employer to see that they were actually approved for that?
Yes. So in a limited fashion. So you will get something from Employment Security that tells you Jennifer Hansen has been approved for benefits between whatever date, July 5th and December 31st. And then the employee would tell you when they need to take the leave because it's going to be intermittent, let's say. You also have the right as the employer to talk to your employees. And I recommend that employers have in their handbook some provision that says that the employee is required to give you a copy of their approval form, their approval letter from Employment Security, because sometimes the letter doesn't make it to the employer as quickly as it makes it to the employee. And so I usually recommend that the employer asks the employee to give them a copy of that, and you can do that, but you don't have a right to get a copy of the medical certification.
Right.
Yeah. And then also when they apply, so if they're taking it intermittently, you have the right to require that the employee provide you with a copy of the documentation showing that they, one, applied for benefits for that week and that it's been approved. And we will talk about PFML too. Okay, so once you have some indication that an employee needs to be out of the workplace for some period of time, you're going to give them the eligibility notice within 5 business days. I don't usually recommend that people wait the 5 business days. If you know that someone's got an issue that's going to take them out of the workplace, just give them a notice because things happen and you tend to forget and then you've not complied with the statute and then there's a problem. So I suggest that as soon as you learn that an employee needs time off, and it seems like it might be for a reason that could be covered under FMLA, obviously at first you don't really know the extent of whatever the issue is. So if it seems like it might be an issue covered by FMLA, then you would give them a notice. And you would also decide at that point, are you going to require a certification or are you going to just give them the benefit? Usually we tell employers to get the certification unless it's something very obvious, but we usually, not for pregnancy, but for other things, we usually instruct employers that it's a best practice to get the certification. And the reason is because you don't want to not get the certification from one employee and then you have another employee who maybe falls into a protected class and you are requiring that person to get the certification. And then that person wants to know, well, why are you asking me to get the certification when you didn't ask this person to get the certification? So we usually just tell everybody to just get the certification. And then once you have the certification from the healthcare provider, you're going to review that and then you're going to make a determination within 5 business days about whether you think that whatever the condition is meets the definition of a serious health issue, and you're going to either give them the leave, or if you don't think it meets the definition, then you're going to deny it. And you would indicate that on the designation notice. So, for example, if a person says they want to take FMLA, but they don't have the hours, they don't have 1,250 hours, you would still give them the eligibility notice and you would mark that they're not going to qualify for it because they haven't worked 1,250 hours. All right, so as far as notice requirements from the employee is required to give the employer 30 days notice if they can. A lot of times they can't. But if it's for doctors' appointments, they generally will know that in advance, so they should be giving you 30 days notice or as much notice as they can give you. A lot of times people will take FMLA for conditions that crop up unexpectedly, like migraines maybe, or IBS, things that they're not going to be able to tell you in advance that they're going to need the time off. So they're still required to give you as much notice as they can give you and to use your normal call-out procedure. The notice can be oral or it can be a written request. They don't need to specifically come to you and say, I want to take FMLA. They just need to say something that kind of clues you into the fact that this might be an FMLA issue. Then also the employer, as I said, can require the employee to use normal call-out procedures. And we generally instruct employers to talk to the employee and tell them, if you're going to call out on an intermittent basis, tell us that you're taking FMLA for that one. So we're not left wondering, is this the flu or is this FMLA or is it? And sometimes employees have different types of leave that they're out on. So it's important that the employee be giving you enough information so that you can track the time and that you can track it appropriately and you can make a determination about whether or not this is an FMLA issue or is this something that should go under their vacation bank or their PTO bank. That's not in the statute, but I find that it's a problem that crops up often that employers don't know why the person is gone. And so we feel that they should ask. The more that you can talk to your employees and find out why are you going to be gone without being intrusive as to their medical history, find out why are they going to be gone. Is this related to your FMLA approved leave? Yes. Okay, great. And then you mark it off. Both parties are required to cooperate with one another. The employee is required to cooperate in the sense that it has to give you notice. They have to give you notice and let you know what type of leave they're going to be taking. Is it going to be a continuous type of leave? They're going to be gone for a month, or they're going to be gone for 12 weeks? Or is this going to be an intermittent leave where they're gone periodically, or they're gone every Friday or every other week? If the employee does not cooperate, in a sense, what I usually see is if the employee doesn't return the health questionnaire from the healthcare provider, and if that's the case, the leave can be denied. But generally speaking, the EEOC wants to see employers try to work with the employee. And so if the employee isn't returning their health certification within the 15 days that you give them, it's usually that the employee couldn't get in to see the doctor within 15 days. And so the EEOC has said that employers should be understanding and should extend additional time. The employee says, I can't, my appointment isn't until next month, which is going to be 28 days and not 15 days. Generally, the EEOC wants to see you extending that additional time to the employee to the employee to get that documentation.
Who has the right to ask the employee why you're being gone?
Well, you should instruct the employee when you're having a conversation about the fact that they're going to be out on FMLA leave. You should instruct them when you call in. Just tell us this is I'm taking this day off related to my FMLA approved leave, just like that. So whoever they would call into could say, is this related to FMLA or is this another reason? Because you're going to need to know if this is vacation or PTO or sick leave or whatever. So that level of questioning is okay. They're not going to want to probably go beyond that, but just finding out how to categorize the leave is fine. All right, so we've talked quite a bit about intermittent leave, but I just want to reiterate that the employee can take their leave either in one block of time or they can take it intermittently, depending on what has been approved by their doctor. So it's going to be tied back to whatever the condition is. And except for bonding leave. So bonding leave, the employer must agree to allow the employee to take it intermittently. Otherwise, they have to take it in one continuous block of time, which is different than paid family medical leave. Paid family medical leave, the employee just say, I'm taking my leave intermittently at this time. Absences that are for a reason are not counted as occurrences, even if they don't have any vacation leave, or they don't have any PTO left or sick leave. It would just be counted towards their 12 weeks of FMLA time. It's not going to be counted as an occurrence. So that's another reason to encourage them to disclose that they're going to be gone for an FMLA related reason, so that they're not being docked. They have like an occurrence program. They're not being docked, or it's not being counted as a performance issue, because you understand that this is leave that's been approved. Unlike the ADA, which we're going to talk about next, FMLA is not subject to a hardship analysis. So what I mean by that is it is definitely a burden and a hardship to have these people gone, especially when they're gone on an intermittent basis. But the employer does not have the ability to assert a defense against allowing them to take this leave because it's causing a hardship to the entity. The employee is entitled to take it so long as the healthcare provider has said it's necessary and they've been approved, even if it's causing a hardship to the employer. Are you changing it too?
Yeah, I don't think that's working.
Sensitive. Every time I touch it, it changes. Okay. So job protection and restoration. If an employee is out, generally when we're talking about job protection and restoration, it's because the employee has been gone for a significant amount of time, not they're gone intermittently. But if they are gone and then they come back, that person is entitled to be restored to their same position or an equivalent position. An equivalent basically means the same position, and you need to reinstate them into a position that has the same type of benefits. It has the same pay, the same location, the same type of responsibilities. So the same status. So really the best practice is to return them to the same job. But if that's not possible, then you need to look for a position that is available, that is essentially this equivalent. All right, so sometimes the employer will have to hire someone to fill in for the person who's been gone for 12 weeks. That person is still entitled to return to their position or an equivalent position, even if you fill their position. So make sure that if you're filling a position, you tell a person that this is a temporary arrangement and that the employee who's gone is going to be coming back. And so that they understand what the limitations are to their job. Now, if the person goes out on FMLA leave and you have a RIF, or the job just goes away for whatever reason, you close down a location, then if that person would have lost their job, even if they would have been there, you don't have to hold the job for them. So if it naturally, the job would have gone away and it's unrelated to the fact that they're gone, you don't have to hold the job. So if you had a ref and the entire department is gone, you don't have to hold that person's position. And then there's also an exception for key employees, which is a very, very, very limited exception. And so there are certain people who are generally high up executive individuals that are so integral to the organization, so important that you would have to replace them. And so that could be an exception to their obligation to keep this job open. Next slide.
Is that the same for PFML?
There is also an exception under PFML too. Yeah.
Just the whole thing, so that's the section on the job protection is for both.
No, but I will get to PFML. There is job protection, but it's harder to get to under PFML. Okay, so ADA, then I'm going to come back to PFML after we get through the Americans with Disabilities Act. The ADA relates to accommodating employees, and the reason that I've included it in this discussion related to leave and attendance is because one form of accommodation could be leave. So the person may need to be out of the workplace as a form of accommodation in order to allow them to recover or get treatment or rehabilitate, and then allow them to come back and perform the essential duties of their job. So the ADA applies to employees with 15 or employers with 15 or more employees. Although I do want to point out that in Washington, we have the Washington Law Against Discrimination, which protects employees based on a whole variety of protected statuses. But one of those is disability. And the Washington Law Against Discrimination applies to employers with 8 or more employees. So if an employee needed to be out of the workplace because of a disability, you would analyze their leave under Washington Law Against Discrimination the same way as the ADA. So I haven't even included it, but just be aware that the Washington Law Against Discrimination is 8 employees rather than 15. So as I said, it prohibits discrimination against a qualified individual based on their disability. And so basically you're looking to see if an employee can perform the essential functions of their job, either with accommodation or without accommodation. You are not, as the employer, obligated to remove essential functions. And what I mean by essential function is the purpose of the job. Like, this is the reason that we have this job. An essential function for a receptionist might be answering the phone and greeting people at the front desk. That's the whole purpose for this job. So you're not required to make accommodation in the sense that you remove essential functions, but there might be peripheral type functions that could be reassigned to others. So the employer is obligated to provide a reasonable accommodation unless providing that accommodation would amount to an undue burden. Keep in mind that when we're talking about the ADA and accommodations, a lot of times I get employers who say, well, how long do I have to accommodate this person? I don't know. You might have to accommodate them for the entirety of their professional career with you as an employee. Or it might be 6 months or a year. It depends on the circumstances and the reason that that person needs an accommodation. So just keep in mind that there is no end date for when this person gets cut off from their need for accommodation unless their condition has changed. Under the ADA, the employee is not entitled to continue their health benefits. Under FMLA, they do continue their health benefits under the same terms as they had them when they were employed. So if they pay a portion of their premium, they still are required to pay a portion of their premium, which is difficult when you have somebody who's out on an unpaid leave and you're expecting them to continue to pay a portion of their premium. So that's a real challenge. But under the ADA, the language of the statute does not require an employer to continue health coverage unless you would continue health coverage for other people who are out, like if they're taking a sabbatical or they're out for some other reason where the law doesn't require you to keep their benefits. You can't treat the person who's disabled in a different way than you would treat anybody else who's out of the workplace. All right, so eligibility. I like to remind employers because lots of times see a very surprised look on people's faces when I tell them that the ADA applies to applicants and employees. So you have an obligation potentially to accommodate an applicant as well as an employee. So usually how I see this play out is that the applicant needs some kind of accommodation in filling out the paperwork that you need them to fill out in order to apply for the job, or they need an interpreter, or they are in a wheelchair, and so the location of the interview has to be someplace that's accessible to them. So just keep in mind that under the ADA, even your applicants are entitled to accommodation. And there's no length of service requirement, since we're talking also about applicants. It's the first day that you have contact with this person, they are entitled to accommodation potentially under the ADA. And then there's no worksite requirements. When we are considering the ADA, we are only considering the ADA for the employee's own condition, their own disability, not their spouse's disability, not their children's disability. That would be FMLA. So when we're talking about the ADA, we're only talking about what is going on with the employee alone. And then again, we're talking about mental health issues as well as physical issues. And those are issues that the phrase that's used is that it limits or impairs. It's a substantial limit on a major life activity. When we talk about major life activities, we're talking about eating, walking, seeing, talking, breathing, standing, bending. I mean, the list is exhaustive. And the EEOC has said that it expects employers to spend less time trying to figure out whether the person has a disability and more time focused on how can we try to accommodate the disability. Notice requirements. So you'll have an EEO poster that you will display. The employee, most of the obligation, at least initially, is on the employee. The employee is obligated to ask for something. But a lot of times, the way that courts have interpreted the ask is not the employee coming up and saying, I need an accommodation for a disability. They'll say things more like, gosh, I'm really having a hard time getting to work because I'm on this new medication. Or I really need to have my bathroom break. It's hard for me to wait for my bathroom break because I need to get there sooner. Or I'm having to get treatment for some condition, and the only time I can get to my therapy appointments is at 3 o'clock, and I'm supposed to work till 4. It's usually something more like that. They're not using the word ADA, they're not saying the accommodation, they're just saying something that's kind of triggering you to think, maybe this person needs an accommodation, and that's enough. So they've done their part. You are now on notice. So now your obligation is to respond to that. And generally, I just tell employers to say, how can we help you? You're not going to promise them that you're doing anything specific, but you just solicit them to start engaging with you in the interactive process. So if you see someone that's having performance issues, they're having trouble, and you think it might be related to something that's going on with their health or their mental health, they're having trouble getting into work because they're having a lot of doctor appointments, those kinds of things, you're going to say, how can we, I've noticed that you're having trouble getting here in the morning. How can we help you? And if they say, oh, I don't need any, great, just document that and keep it in your file. Now you've satisfied your obligation. If they say something more, then that starts the interactive process, which we're going to talk about in the next slide. And then the cooperation obligations is that both parties are required to, in good faith, participate in the interactive process, which is just a conversation. It's an ongoing conversation between the parties. And if an employee refuses to participate, that could be a justification for the employer declining to offer the accommodation. So the interactive process, like I said, you're going to start it with how can I help you? And you are going to brainstorm, you're going to think outside the box, you're going to try to come up with creative ways to allow this person to still perform the essential functions of their job. If they have a limitation, you can get documentation from a healthcare provider if you feel that you need it. If it's something easy, like they say, gosh, it would really be great if I could have a stool. You're probably just gonna give them the stool and not go through the whole hassle of contacting their doctor and waiting for it to come back and then having it come, you're just gonna give them the stool. And then you document the fact that you engaged in the interactive process, they said they needed a stool, you gave them the stool, and everybody seems satisfied with that. But if it's something more involved, like I need to work from home, or I need to change my schedule, or I need to totally reconfigure my entire workspace, you're probably going to get some documentation from their healthcare provider. And what you're going to get, we have forms that we have tailored. There's also an organization called JAN, which is the Job Accommodation Network, and they have forms that you can use that basically just asks the healthcare providers who work through the employee, give the employee the form with a job description, and the employee takes it to their healthcare provider, and the healthcare provider lets the employer know what kind of limitations this person has. We don't care what their diagnosis is, we care what they can and can't do. And then you're going to work on helping that person be able to perform the essential functions despite the fact that they have these limitations. So if they need to get to the bathroom very quickly, maybe you're going to move their workstation so it's closer to the bathroom, or you're going to give them a new different parking spot, or you're going to allow them to go into a quiet room and put on noise canceling headphones because they need time to relax. So you're going to start that process, and if you need to get information from the healthcare provider, great. Sometimes the healthcare provider comes up with suggestions. You don't have to take the suggestion of the healthcare provider, but sometimes they have good suggestions. You are going to talk to the employee, and you're going to look at the job description and say, how do we make it so that we can get you to perform the essential functions of this job? And the employee may come up with suggestions that are good. They may come up with suggestions that are bad. You do not have to take the suggestions of the employee, but you have to, in good faith, discuss what are some options. Okay, here's what I suggest we try. We're going to move your parking spot closer to the front door and see how that works. And the interactive process is a continuing discussion. So you don't just talk to them one time, you go back. How's it going from your perspective? How's it going from our perspective? If it's not working, then you adjust it and you come up with a different solution if you can. But you're obligated to accommodate them unless accommodating them would be an undue hardship, which we're going to talk about in just a minute. So I think, like I say at the bottom, the safest approach is to consider any notification as requesting accommodation. So don't be afraid to talk to that person about what they need. A lot of times I will have employers call and they say, oh, they say they can't go out to this remote location. So, I mean, that's his whole job. Like, what are we supposed to do? We're just going to have to fire him. And they haven't talked to the employee. And lots of times employees have really creative, good suggestions for how to make it work because they're the one that's been doing the job. So talk to them about it. Not only is it your obligation under the law, but it's the best way to actually come to a solution. And it's way better to have an employee who's already trained and continuing to perform their job than hiring somebody new and having to get that person up to speed who's an unknown quantity. So talk to the employee and let them know that we're going to continue to talk about this. And let's just try this for 6 weeks or a month and see how it goes. And then talk to the supervisor. How's it been going? Talk to the employee. How's it been going? And if you need to make adjustments, make adjustments. Okay. These are just some types. People always say, well, can you tell me what are some accommodations? I can't really because it depends on what the situation is. It depends on who you are as an employer. Depends on who the employee is. What is their condition? What is their working environment? But remember that leave can be a form of accommodation, and that's why I've included it in here. Sometimes working from home could be at least a temporary accommodation. Another question I get a lot is, okay, so they want leave. How long is a reasonable amount of time? I don't know. Courts have said even 6 months is reasonable. It just depends on the circumstances. So you're going to stay in touch with that person and your supervisor. You know the needs of your organization better, and then you're going to start evaluating at what point is this turning into an undue hardship. Remember that if the person just says, I just need to be gone, I don't know when I'm gonna be back. That's not a reasonable accommodation indefinitely. Or I just wanna come and go as I please. That's not a reasonable accommodation. You need a little bit more definition than that. Okay, next slide. Undue hardship is a very difficult standard to make. So what you are going to do is you're individually going to consider what is the job, what are our capabilities, what is their limitation, can we make this work? Is there anything that we could do to help this person be able to perform the essential functions of their job? You're going to look at things like how much is it going to cost? But I will tell you that courts do not look favorably on the one and only argument being it costs too much. There needs to, generally speaking, there needs to be more, unless it's we need you to remodel your entire office. That would probably be cost prohibitive and an undue hardship. But generally, we like to get as much objective evidence as to why the suggestions, here are all the suggestions, and none of these are going to work. Why aren't they going to work? Well, because, and the more objective you can be in your evaluation of why the suggestions won't work, the better off you will be. So make sure that you're really thinking outside the box and you're really giving a good effort to trying to come to a solution. So you're going to look at your operational impact and where are you located? What kind of business are you in? What are your assets? Do you have a lot of money? Then a court's probably going to be less sympathetic to you making a financial type argument that it was too cost prohibitive if you make $1 million, which I'm sure is, it's going to depend on how much the accommodation would cost. So just make sure you're doing an individualized assessment. If you've had somebody else come to you and say, I want to work from home, and you've looked at it in the past and it's just not going to work, look at it again for this particular person under these particular circumstances in the place that you are now in your organization. Because especially if you've had people working at home during COVID, it's a much harder argument to make that working from home isn't going to work. Not to say that you can't make the argument, but it's just harder. Okay. And then under the ADA, it's a little bit different. The employee must be returned to the same position. So if they are out as on leave as an accommodation, they are required to be returned to the same position unless it would be an undue hardship. If you cannot accommodate an individual because for whatever reason what they need just doesn't work with your operation, then you're going to look to other open positions within your organization, and their salary can be affected by that. You're going to look at first equivalent positions and then lower positions, and then there really is no way to accommodate this person, or even with accommodation, they can't perform the essential function. They're not qualified anymore, and you may have to go separate ways. All right. So a lot of times the first time you hear about the need for an accommodation is during a performance evaluation or when you're disciplining somebody. So what I suggest that employers do is finish your performance evaluation or your discipline before you start talking about accommodation. Because remember, it is their obligation to inform you that they needed an accommodation, and they still have to be able to perform the essential functions of their job. So if they haven't told you anything about needing an accommodation, and that's true, you might want to check with the supervisor to make sure that that's true. But if they have not told you that they needed an accommodation, that is their obligation. So finish your performance evaluation or whatever issue that you're addressing with them at that point. Finish it first and then move on to discussing how can I help you, what's the condition or what's the issue. Can we come to a resolution about an accommodation that would work. Okay. So let's move on to PFML, paid family and medical leave. Almost all Washington employers are going to be subject to PFML, and employees enjoy the benefits of PFML. It does provide partial wage replacement for, again, family or medical leave. The difference with the difference with PFML from FMLA, one of the differences is that you have 12 weeks in two different buckets. You have 12 weeks of family leave in one bucket, and then you have another bucket that's 12 weeks of medical leave. So really, they have two separate buckets of 12 weeks of time. If an employee has an issue where they need both types of leave, they can't exceed 16 weeks unless it's related to a complicated pregnancy, in which case they can take up to 18 weeks. But ordinarily, you're not going to have someone exceeding 16 weeks, even if they need time for themselves and they need time for their child. A lot of times when you have an employee who's out because of the birth of a child, they'll be out for 16 weeks because they'll be out first for their own medical condition, and then they'll be out for the bonding leave, and so they get 16 weeks. Eligibility. The employee has to have worked for a Washington employee or employer for at least 820 hours. And that's any Washington employer, not you specifically. So as long as the employee works for any Washington employer for at least 820 hours during the year, they may qualify for benefits. The good news about PFML, it's the good and the bad. The good news is that ESD makes the decision about whether they qualify for benefits, so you don't have to do that. All your obligation is to give them a notice about it, and then they apply through Employment Security, who makes the decision. The bad news is that you're left a little bit more in the dark because they're dealing just with Employment Security. There are some other eligibility requirements for job protection, which we'll talk about in a slide or two. Okay, so the covered reasons are very similar to FMLA. So again, a serious health condition, and it's either the employee's own serious health condition or a family member's serious health condition. And in this instance, family member is defined differently, and we'll talk about that in a moment. They can also take leave for bonding, as we've said, but it has to be used within the first 12 months after the child is either born or placed with the family. And then a more recent addition is that there are provisions for bereavement leave for the 7 days immediately following the death. It's only going to be applicable in the case of the death of a child, though. So it's not going to be generally applicable. That was kind of a gap. So if the mother went in, had a child, and it was stillborn, they didn't get any time because they didn't have bonding leave because there was no child to bond with. So it was the state's attempt to kind of fill that gap. So they get up to 7 days immediately following the death of the qualifying family member. Okay, next slide. Again, serious health condition is going to be the same as under FMLA, so that should be familiar to you. Like I said, ESD is going to make the decision here, though. But if you hear employees saying something that you think might qualify them for PFML, it kind of sounds like FMLA. It sounds like they might have a family issue, or just give them a notice and let them apply and let ESD sort it out. Family member, again, spouse or domestic partner, a child, a parent or a parent-in-law, grandchild, grandparent-in-law, sibling, son or daughter-in-law, or the catch-all, someone who has an expectation to rely on you for care. They don't have to live in your household. And this includes both physical care and psychological support, which is the same for FMLA too. They don't have to actually be attending to the person, just be supporting them. Yeah. Yes. It's much broader under the state. Much broader. Okay, next slide. Notice requirements. Again, there's a poster. If you hear some situation that seems like it might entitle the person to some kind of leave for a family issue or a personal medical issue, just give them the notice. The notice can be found on the ESD website under the employer tab. You're required to give them a notice within 5 days of the 7th consecutive day of absence, which seems very confusing to me. I say just give it to them. If you hear about it, don't delay, just give them the notice. The employee has an obligation to give you 30 days notice, again, if the reason for their being away from the workplace is foreseeable. Otherwise, they are required to just give it to you as soon as possible. The notice under the PFML statute is required to be in writing, but notice that the WAC specifically provides for the employees to give notice by text message. I know that a lot of employers have policies that say no texting. but this statute actually says that they can. So it can be handwritten notice, it can be typed, email, or text. And then the employee has that obligation to cooperate by giving you notice about when they're going to be gone and for how long. Okay. Again, if they're going to be out for a PFML reason, it's not going to count as an occurrence again. If it's not covered under PFML, if they're denied benefits, don't forget about the other types of leave. Maybe it's covered under FMLA, maybe it's covered under the ADA, maybe it's covered under some other type of leave. So if you have employees who are out of leave, especially don't forget about the ADA. I have lots of calls from people who say they're all out of vacation, out of PTO, out of everything from fire. No, now you have to go through the interactive process and figure out if they have a disability, are they entitled to leave as an accommodation, or to come into the workplace and be there, but just have some type of accommodation.
So are you saying that PFML may be more generous as far as who they identify as a family member, but not necessarily as how they define a serious health condition?
It's the same as FMLA.
That's what I thought.
Yeah.
It was the same. Okay.
Yep, that's right. Something else to keep in mind that, especially for employees who are out on intermittent PFML, remember that they have to take it obligated if they want to get benefits for that year, they have to that week. They have to at least take 8 consecutive hours in 1 week. So that can be a whole day, 8 hours, or it could be 4 hours in the afternoon and 4 hours the next morning, and that's 8 consecutive hours. If they don't have 8 consecutive hours, none of the time is going to be covered and they will not receive a benefit for it. So I find it's helpful for employers to understand that they're obligated to at least have 8 consecutive hours. Now, even if the 8 consecutive hours is on Friday and they had an hour on Monday, an hour on Tuesday, 2 hours on Thursday, all of the hours will be covered so long as at some point during the week they had 8 consecutive hours leave. Oh. Again, there is some job protection. This gets to your question that we were just talking about. So if the employee is entitled to job protection, they must be returned to either the same or equivalent position. But they're only entitled to job protection if basically they fit within the FMLA standards. So they work for an employee with 50 or more employees. They work for an employer with 50 or more employees. They've worked for the employer for at least 12 months at some point. They have worked for you as an employer for at least 1,250 hours in the preceding 12 months. So, so that kind of gets back to the FMLA. So for purposes of job protection, they're going to have to satisfy the FMLA standard.
What if, does that 50 plus employees, does that include the public, for conservation?
Yes.
Okay.
Yeah.
Then what happens if there's a union involved?
So if there is a union, the law is what it is, but you should always, I'm glad that you brought that up because I intended to mention it in the beginning, you should always be looking at your CBA. But hopefully your CBA isn't contradicting what the law is. And if it is, then you're probably need to talk to your labor counsel. But you're always going to be looking at your CBA before you take any action against an employee. But as far as the job protection under the PFML statute goes, they have to satisfy these obligations. Job protection under a CBA, you look to the CBA. So you're going to be looking at both.
So job protection under PFML falls to the FMLA standards?
Yeah. Except for the 75-mile radius, but everything else.
Okay.
So you're
So
just looking
most-
at you.
Yeah.
Do they work for you for a year? Do they work for you for 12 months?
Most of us, or probably all of us, none of us have 50 employees. So they're not going to have job protection. Okay.
Unless you want.
Well,
to.
sure. Yeah.
Everybody.
Yeah. But under the law, they're not protected.
Yeah.
Okay.
Okay, next slide. PSL, paid sick leave. So I'm starting to run a little behind here, so I'm going to speed up a little bit, but hopefully this is not a new statute. It's been around for a while. Hopefully everyone is familiar that employees who are non-exempt are getting at least 1 hour for every 40 hours worked. If you want to give them a more robust paid sick leave plan, that's fine. They need to at least be accumulating 1 hour for every 40 hours work. And then there are some municipalities that have more generous requirements. But as far as the state law goes, so employees start accruing PSL on their very first day, but you can restrict them from using it for the first 90 days. They can use the PSL to be diagnosed, to go for preventative care, to get doctor's notes, to care for their children, take their children to the doctor. All of those will be covered, including domestic violence. It's actually paid sick and safe leave. So you would include if they need to be out of the workplace related to domestic violence, that's covered under the paid sick leave statute as well. You're going to be giving your employees notices each month about how much they've earned, how much have they used, and how much they have available. If you want to require the employees to give you reasonable notice, which I assume everybody does want to do that, you need to have a written policy, and it should be in your handbook. Also, if you want to have a calendar year and accrual year that's other than just a calendar year, if you want to require them to give you a doctor's note after they've been gone for longer than 3 days, you can only do that if you have very specific language in your policy. So a lot of employers are asking employees for doctor's notes, non-exempt employees for doctor's notes right away when they're using their PSL, and you cannot do that. You cannot ask them for a doctor's note till after 3 days. And you have to have that. Okay. And you have to have that policy. Okay. You can't require your employees to use PSL. So a lot of employers have a PTO program, and so they've rolled their paid sick leave time into their PTO plan, which is fine. But if you do that, you either have to still track the time separately, which why bother to have it combined? So you would still have to track how much of this is paid sick leave and how much of this is vacation. Or the entirety of the time has to follow the paid sick leave statute. So that would mean that you couldn't require your employees to use their PTO at all, because it would all have to fall under the PSL statute. The PSL statute says you cannot require employees to use it. Now, they don't get the benefit of the protection of using paid sick leave if they don't designate it as paid sick leave. But something to keep in mind, because a lot of times employers will have employees required to use their PTO concurrently with their FMLA. But if you have your PSL time rolled into that, you can't do that because you can't force them to use their paid sick leave time. That's kind of a tricky one. Also, if you have people working on shifts and they take paid sick leave, you can't require them to fill their shift. That's prohibited also under the statute. And also they have to be able to roll over up to 40 hours of unused PTO per year. Okay, let's move to the next one, which is pregnancy. And the Pregnant Workers Fairness Act is a new federal law as of last year. Washington has a very robust pregnancy protection statute. And so us in Washington are used to already providing protection to our pregnant employees. But this is a statute under federal law because pregnancy is not a disability, so it's not covered under the ADA. So for people outside of Washington who didn't have robust pregnancy protection laws, those pregnant women they were not entitled to an accommodation unless they had a disability that wasn't just pregnancy. So you are required to provide reasonable accommodation for known limitations, even if that means that the employee cannot perform the essential functions of their job, as long as it's a temporary condition, which the EEO is saying now they think it's 40 weeks. Probably it has not been litigated, but probably 40 weeks. So if the employee says, I can't do X, and that's the essential function of their job, as long as it's a limited time, then you would have to accommodate them by not having them do that essential function. So that's something very different.
Is that the same with ADA if it's just expected to be a temporary disability?
So under the ADA, they still have to be able to perform
That's
essential
okay.
functions. Now, marginal functions like, also you run and get coffee or, whatever, that's not really your job. That you can assign off to other people, but you're not required to assign away essential functions.
Okay.
So let's move. So the next one is just about Washington law. So let's kind of skip that one because it's basically the same thing, except for under pregnancy disability. If an employee is disabled because of conditions related to pregnancy, they're basically allowed as much time off as they need to attend to that disability related to pregnancy. I mean, there's gonna be an end to it because they're gonna have a child. But if they need to be on bed rest for 9 months, they get to be on bed rest for 9 months. Okay, let's go to the next one. So then just additionally, I just wanted to make sure to point out, like domestic leave, they get as much time as is reasonable to attend to things like getting a restraining order, meeting with an advocate, trying to get safe housing, meeting with a lawyer. They get as much time as is reasonable, which is an undefined term, but as is reasonable. Emergency services personnel, so people fighting like wildfires, for example, there's protections for them. USERA is military leave, and don't forget about your vacation and your short and long-term disability policies, and then workers' comp, of course, people may be out because of workers' comp. So that's it, yes. What's that? Let's go back. They are not paid, well, vacation would be, and then potentially short and long-term disability. But, and then I guess workers' comp also, as long as your injury is, accepted. But domestic violence leave would not be, emergency services personnel not, USERA would not be. Okay, thank you all very much. Sorry to kind of got rolling a bit so fast.